So, what is the chapter about? Act about general clauses. Yes? Fine. Purpose for understanding other acts or regulations, correct? So, if anything, there is any issue with interpretation, we can use this act, okay? So, an act for understanding rest of the acts or regulations is general clauses act, and these are the chapters which are in the act, fine? So, why are we studying? For having general definitions, or where there is no definition given in a particular act, we can give reference to this act. Yes? When did it start? The act? 11th March 1897, correct? I also told you Article 367 of Constitution of India talks about giving reference to this General Clauses Act. That means if you want to understand Constitution, or if there is any confusion in understanding Constitution, you can take a reference of this Act, where it is given Article 367 of the Constitution, correct? Then Section 5 to 13 is distributed in two parts. One is about when an act will be enacted, when it will be repealed, etc., etc. And secondly, it is about general rules which we use for understanding time, distance, gender, etc., right? Before we proceed, what do you mean by preamble? It is a small short summary of the act, yes? So is first of all preamble taken help of for understanding a particular act? That means will it help you in interpretation? Preamble helps you. So it is a general guidance summary of the act. So you can take help of that, yes? So it is the main source of understanding the intention of the lawmaker behind the act. Can it override the enactments, provisions? Preamble, can it override any of the provisions given in that act? No. Yes, it does not. It doesn't have that authority. But only a reference can be made. Important over there in preamble, you have to use these words, okay? Preamble gives you scope, object and purpose of the act. These three words are important. Scope, purpose and object of the act. Definitions are generally given in preliminary chapter. Preliminary, remember, beginning of the chapter. Section 1 is usually what? Section 1. Short title and jurisdiction, correct. And purpose you can say, very small. Short title, remember? Long title, short title. Okay. And section 2 is generally about definitions part, right? So we use this act or definitions given in this act if there are no definitions given in any of the particular acts. So what do you mean by this? Means and includes. So these are the types of definitions first of all. Any definition may have this word means or includes. So what do you mean by whenever the word means is used? Exactly, accurate, particular those words only. And includes is a wide definition. Whatever can be part of it is inclusive definition, correct? And the other part we call it as exclusive. Otherwise you can say exhaustive also. Why exhaustive? Limitations. That means it is exhausted, it is utilized completely. You cannot put any other words in that definition part. Whereas in inclusive, it is a little bit, or you can say accommodating. That means you can put any other words also in that meaning. Fine. So these are two types of definitions, inclusive and exclusive, means and includes. Shall and may. When do we use shall? What is the meaning of that? One of them is compulsory, other is not compulsory, voluntary you can say, okay? Or mandatory or voluntary. So which one is mandatory? Shall. And may is voluntary. But usually at times it may also be used other way around. We have seen those cases. Somewhere also we have said it is a matter of courtesy. You understand courtesy? Little bit you can say in a friendly manner. And because shall is very much authoritative, directory in nature. In that case you may use the word may, but the intention was always that it is compulsory. So you also have to understand the intention behind giving that word. Fine? Then affidavit, meaning is given in section 3, subsection 3. Again it is a document, declaration for affirmation, giving some details by swearing, correct? Instead of swearing. Affirm or declare. It is a written statement confirmed by oath or by affirmation for use as evidence in court or before any authority. So it will be a valid evidence, affidavit. Commencement. So from the day from which your particular act is getting enacted or in force, that will be the date of commencement. Document includes, correct, inclusive definition, 318. Any matter, so it has to be a matter, then it has to be written matter on the document, express or describes upon any substance, any material basically, by means of letters, figures or marks, or by any of these combinations, right? So not necessarily those words has to be alphabets, anything, it can be letters, figures or marks. Again, and what is the purpose? For recording it. You record it so that you can again refer to it later on. Financial year is always from the first day of April, and the meaning of year is 365 days. So if at all it will mean from 1st April to 31st March. Yes. Good faith means what? Bona fide. Anything done, anything honestly. Whether it is done negligently or not. Negligence, you understand? That means not being very careful, but still you were not careful in good faith. Correct? Immovable property 326, it includes again inclusive definition. What all? Land, benefits arising out of land, and things attached to the earth. Then we also discussed what is immovable, or like just because it is attached to earth doesn't mean it becomes immovable. We have to go beyond those things. We have to understand the facts as well. Correct? So when it becomes difficult to move anything from one place to another, in that case we call it as immovable. Right? So permanently fastened to anything attached to the earth. I think I told you an example of small machinery which is attached to earth with just 2, 3 or 4 screws, but which can be immediately removed and put somewhere else. It doesn't become immovable as such. Correct? Trees are immovable property because trees are benefits which arise out of land. However, timber is not an immovable property. This example, famous example we have done. It is also part of your question bank in the material. Okay, same question. Buildings are immovable. Machinery is also immovable. Person includes company, association, body of individuals, whether incorporated or not. Swearing means, again, these are all same things. Swearing, affidavit, oath, swear, etc. Yes. So what is important is that application to definitions to previous enactment, section 4. Application to definition to previous enactment. That means any of the acts which were in place before this act 1897 के पहले, उसका क्या था हम लोगों ने बोला था? Application of terms expression to all the central acts made after the 3rd of January 1868 and all to the regulations made on or after 14 January 1887, following words shall be used. कौन से वाले? Affidavit, immovable property, imprisonment, month, movable property, oath, person, section and year. Shall also apply to all central acts made after the 3rd day of January 1868 and all regulations made on or after 4th January 1887. That means these two acts, one is a central act and another is regulations, but it was before this general clauses as 1897. These words will have the same meaning which is given in this general clauses act. Again, that means it is words wise, specific word wise from when they are applicable. General rules of construction. So, when usually do we say is the commencement of any particular act or regulation? As on the date on which it comes into force. I mean, when does it come into force? When it is given assent by President of India. So, those acts which are formed after 1947, because we didn't have President before that. So, for them, President. And before 1947, that means after General Clauses Act 1897 and before 1947, those acts will be coming into force when given assent by Governor General of India. Good. Because we didn't have constitution by that time. Operation of enactment. The operation of statutes can either be retrospective or prospective. Retrospective means from beginning or from past. Prospective means from future. So any act should not be retrospective which affects existing rights or creates new liability obligations or imposes new duties. Same thing, correct? As far as possible. These are examples. Effect of repeal. What do you mean by repeal? Repeal means abrogation. What do you mean by abrogation? Annulment or basically cancellation or obliteration. Obliteration means eradication. That means removal of one of the statute. So when an act is removed or repealed, it should be considered that it was never had come into existence in first place. Correct? A statute is either perpetual or temporary. Perpetual means permanent. or temporary. That means for a particular time period or for a particular purpose. It is perpetual when no time is fixed for its duration. This is okay. If no time period is given, then what we'll assume? The act is perpetual, permanent. And if some time period or some time is given as such, in that case, the statute is temporary. Yes. Where any central legislation or any regulation made after the commencement of this act repeals any act made or yet to be made, unless another purpose exists, the repeal shall not revive anything not enforced or prevailing during the period at which the repeal is affected or affect the prior management. All this are prior effects. Any act which is repealed, in that case, after the date of repeal, whatever has happened, that has happened. You cannot change that. We had summarized that way. If in any act the punishment is given of 7 years and after that act is repealed, you cannot change that. Even if in the new act it is 10 years or 5 years. So what has happened, correct? No rights, no duties, no obligation, nothing will change what was existing in the previous act. Yes, this we have discussed. So effect of repeal is what? The effect will be given such that we will consider that it never existed in first place. Correct? If the prosecution has not ended before the expiry of the act, that means continuing prosecution. Prosecution means some legal proceedings is going on against, let us say, a person, but as on that day of during that course of that proceedings, the act has been repealed. In that case, what will happen? The entire proceedings will be cancelled. You cannot now award any judgment or award any punishment in the repealed act, because that is now over. Now you will have to consider him against now in the new act. Okay. The person who has been prosecuted and sentenced during the continuation of an act. Okay. So crime has been done, prosecution has been done, and sentence, award has also been done. This is okay. Cannot be released before he serves out his sentence, even if the act expires before serving of full sentence. So like we said, what has been done during the life of the repealed act, that cannot be changed. Revival of repealed enactments. When a statute effects a repeal of an existing statute, question arises whether repealed statute revives on expiry of repealing statute. No. That means what? One is what? A repealed statute, old act. The new one will be the one which is replacing it is called what? Repealing act. Correct? Samajh rahe ho? So originally we had act number 1, let us say. It is repealed with now repealing act number 2. The question is, even if now act number 2 is repealed by repealing act number 3, what happens to act number 1? This we had discussed. So act number 1 will not again be revived automatically unless there is some provision given during the time of repealing of act number 2. We had discussed this, right? So the first act is not revived unless the third act makes an express provision to that effect. During the time you are repealing from act number 1 to act number 2 to act number 3 in that time. Construction of references to repeal enactments. Okay, if there is some reference given, this case, one act is given the reference to definition or some part of some another act. In that case, that act number 1 is repealed, then what will happen? Even act number 2 will automatically give a reference to that new act or other act to which the act number 1 used to give reference to. I think that example of some definition we had checked. Digital signature also, and there is also some book profit definition, I guess. Or Companies Act. Whenever there was some reference given by Companies Act 1956 to Income Tax Act 1961. Now, Companies Act 2013 is repealing 1956. So, whatever references were given in 1956, those references will continue in 2013 to the same Income Tax Act 1961. Commencement and termination of time. What word do you use? Commencement and termination of time. That means a time period. That means from date to date. In that case, we include some word and exclude some day and exclude some day. Correct? So, what example you had said? If a company declares dividend for its shareholders in its AGM held on 30th September. So, as on the date of AGM, you have declared dividend. So, you have to pay in how many days? You know, Companies Act also now. 30 days. So, will you calculate 30 days from 30th September? No, you will calculate from next day. Correct? That means what? The day of declaration is not taken into account. Correct? For the purpose of excluding, so in this case, it shall be sufficient for the purpose of excluding the first day, whenever you announced it, excluding the first day in a series of days or on any other period of time to use the word from. And for the purpose of including the last in a series of days or any other period of time to use the word to. That means from that day, that day is not calculated from wala day, correct? And to wala day is included. Remember, section 9. Okay, section 9. Computation of time. If a court or office is closed on that day or the last day of the prescribed period, the act or proceeding shall be considered as done or taken in due time if it is done or taken on the next day afterwards on which the court or office is open. Any proceedings is going on, any time is given, time period, and if the time period is falling on an off, whenever that court is not working, then in that case it will be sufficient if it is done even on the next day, correct? Yes, no, agent for 7 days, agent for 10 days, etc. The 10 days falling on when the court is not working. So you can come on the 11th day as well. Section 10. Measurement of distance 11. Distance will be calculated as per between two places on a straight line on a plane. These two things important, na? Straight line on an horizontal plane. Correct? Duty to be taken pro rata in enactments. Pro rata means what? Percentage wise. Wherever any enactment now in force or hereafter to be force, any duty of customs or excess or in nature thereof is leviable on any given quantity by weight, measure or value of any goods or merchandise, then a like duty is leviable according to the same rate on any greater or less quantity. If, like I said, there was some case I had given you, the rate of duty, for example, is let us say 5 rupees per 1000 kg. So that is the ratio or rate, you can say 5%, etc. Whatever, 0.5%, correct? In that case, that same will be applicable even if the quantity is now more than 1000 or less than 1000. So that proportion or that rate will continue. Pro rata, proportionate. Gender and number. Gender, that means masculine will include feminine and or vice versa also. And words in singular shall also include plural and vice versa. Correct? Both gender and number, section 13. Power conferred to be exercised from time to time. This is okay. So where any central act or regulation made after the commencement of this act, any power is conferred to any person. Conferred, you understand? Given. Any power is given, then unless a different intention appears, that power may be exercised from time to time as occasion requires. Just like your act is perpetual, the power given to you is also perpetual. You can use it as and when required. Unless, of course, there is some other problem or any other intention which is appearing in the act. Correct? Power to appoint to include power to appoint ex officio. What do you mean by ex officio? In that capacity, in that you can say authority, in that chair or place we had discussed. Correct? For example, you had seen appointment of which committee? The president is always there. We had seen, no? See the last example. The Vice President of India is the chairman of Rajya Sabha by default. By default means what? Ex officio. By that position. So whoever is there in that seat is automatically appointed over there. So appointment is by ex officio is as well. Okay. So ex officio is a Latin word which means by virtue of one's position or office. Okay. So if you have to appoint someone, you can appoint him ex officio as well. That means without naming that person, but you are appointing that position. Got this point? Section 15. Power to appoint to include power to suspend or dismiss. Fine. So if any person or authority is given the power to appoint someone else, it is deemed that he also has the power or authority to suspend or dismiss that same person. That was section 16. 19. A law relative to the chief or superior of an office shall apply to the deputies or subordinates lawfully performing the duties of that office in place of that superior. Replacing any authority or power given to seniors can be used by juniors as well, only when they are acting on their behalf, under their capacity or directions. Provisions as to orders, rules, etc. made under enactments, section 20 to 24. Construction of orders, etc. issued under enactments. So any orders, see all these words, rules, regulations, notifications, orders, schemes, forms, bylaws, etc. They will have the same, you can say, effect or standing as whatever the act has. Correct? So even if they are not a part of your provision or enactments, they'll still have the same standing. Correct? So they have the same respect meaning as in the act or regulation conferring the power. Okay, what it is exactly? Then the expression used in the notification, order, scheme, etc. shall, unless there is anything contrary in the subject or context, have the same respective meaning as in the act. Okay, whatever words are used in all these documents, okay, those words will have the same meaning, whatever is the meaning given in the act. Power to issue, to include power to add, amend, vary or cancel notification, orders, rules or bylaws. This is okay. So if any authority is given to any person to issue notification orders, etc., they also, it is deemed now, they also have the order to change, vary, cancel those, all these notification orders, rules, etc. Who makes rules for income tax? You have Income Tax Act, you have income tax rules, correct? Income Tax Act 1961, huh? Okay, and you have rules also, okay? Those rules are given by CBDT, okay? CBDT has authority to give rules every year. So at times it happens that your budget happens on 20th February or 1st, now it is usually happening earlier, 1st February. Your act, the book comes after 1.5 months or 2 months, once it is given assent by President, etc., etc. But since it is given by act, by President's assent, act comes later on. But since the authority of rules is with CBDT, okay, are you understanding? The authorities are different. Since it is a CBDT, it happens that rules come earlier than the act itself. That is also possible. Or it may also happen that at times CBDT is very lazy. They may not issue rules also, or it at times comes very late also. So it depends on the person who has the authority to make these rules. Got this? So making of rules or bylaws and issuing of orders between passing and commencement of an act. Okay, so what it is? So after passing and commencement, between that period, Section 22 provides for making of rules, bylaws and issuing orders between passing and commencement. Power to make rules, issue orders may be exercised at any time after the passing or making the regulation, but statutory instruments like rules, orders so made shall not take effect until commencement of the act. So you have the authority to make them, these rules, orders, circulars, etc., when after passing of that act, before commencement also you have that authority, but from when they will have effect from the date of commencement of the act. Provisions applicable to making of rules or bylaws after previous publications. After previous publication, Section 23. We had an issue over here. Section 23 talks about details as to the manner of complying with the requirements of pre-publication of rules, bylaws. The main object and purpose is that before the rules are made and should be given by the authority to those who may be affected by them or making suggestions or to modify them. The authority having power to make rules or bylaws shall, before making them, publish a draft of the proposed rules or bylaws for the information of persons likely to be affected thereby. Last paragraph is important. What? The authority which has, authority who has the power to make these rules, regulations, what will do? They will first publish a draft. For whom? For general public or basically public who will be affected by these rules or regulations, so that they can have their say before these are finalized. Yes? Provisions applicable to making of rules after previous publications. Second paragraph C. The main object and purpose of publication means publication at large, is that before the rules are made, an opportunity should be given by the authority to those who may be affected by them or make suggestions or modify them. So who are affected by these rules, regulations should have a say while finalizing these rules, regulations. Then their process is given, how you can publish that, correct? Are you understanding? Publication of draft rules. Draft we are talking of before finalization. You can publish it anyhow, newspaper, website, etc. There shall be published with the draft a notice specifying a date on or after which the draft will be taken into consideration for finalization. Yes. The authority having power to make rules, bylaws, and where the rules, bylaws are to be made with sanction, approval, or concurrence of another authority, that authority also shall consider any objection or suggestion which may be received by the authority having power. Like you had given the, I think, example, it is approved once by Lok Sabha, then by Rajya Sabha and all that. So one authority is confirmed by another authority. That second authority will also take into consideration any comments given by people who are affected by these rules, regulations. And once it is given by official gazette, it will be the conclusive proof that now rules, regulations have been duly made. Continuation of orders issued under enactments, repealed and reenacted. Under enactments, repealed and reenacted. Okay. Where any central act or regulation is after the commencement of this act, repealed and reenacted with or without modification. That means they were cancelled and again reenacted. Unless otherwise expressly provided, any appointment, unless it is otherwise expressly provided, any appointment, notification, order, scheme, etc. issued under the repealed act continue in force and shall be deemed to have been made or issued under the notification or issued under the provision so reenacted. That means whatever were the rules, regulations, forms given in your repealed act correct? They will continue in the when that act is again revived or reenacted, correct? So you had an act, you had the regulations etc. in that act, and that act was repealed, and now you have again reenacted or revived that act. So what will be the effect? Those again rules, regulations, orders, forms, circular, they will again be revived. Yes, they will continue in force. Recovery of fines, section 25, section 63 of or 270 of IPC and provisions of CRPC for timing in force in relation to issues and execution of warrants for levy of fines shall apply to all fines imposed under any act. That means those process followed under section 63 to 70 for recovery of fines that will be used for any of the recovery of fines in any of the acts. For example, kya tha? You approach the collector. Collector will snatch your property, freeze your property, saying that it is a land arrear, correct? Na? Land revenue ka arrear. In that case, collector has the authority to freeze that property, attach that property and sell that property. Yes? Collector has lots of power in his jurisdiction. Provisions as to offence punishable under 2 or more enactments. Oh, okay. One person cannot be punished twice for the same crime. Remember, we have discussed. So, now, where an act or omission constitutes an offence under 2 or more separate acts. Okay. So, let us say there is a fraud done by company, for example. So, it is a, you can say offence in Companies Act as well, and let us say in another act as well. IPC, for example. Okay. Again, after all, company is a person. Correct? In that case, an offender shall be liable to be prosecuted and punished under the either or one of those enactments, but shall not be punished twice for the same offence. Okay, so you'll follow only one. Correct. So the protection against double jeopardy. Jeopardy, what do you mean by jeopardy? Jeopardize. Put something in risk. Correct. So double, that means you'll not put some person twice. Double, you'll not prosecute him double. That's it. Okay. So the protection against double jeopardy is also recognized in our constitution in Article 20, subsection, let us say, sub 1, 2. Which says no person shall be prosecuted and punished for the same offence more than once. That means he will not be punished twice. Importantly, I think double jeopardy is mainly for if you have done a crime, you will not bring him back to court again. You will not try him twice. It is like meaning of service by post, section 27. What was it? So service by post will be sufficient, or will deem that there has been valid service by post when it is properly addressed, prepaid, that means stamps are there, and posted by registered office. These are three combined kya bolte hai? Conditions. All three should be there, no? Even if one of them is not there, we'll say it is not properly followed. Correct? So letter containing document to have been affected at the time at which the letter was delivered in the ordinary course of post. A letter containing the document to have been affected at the time at which the letter was delivered in the ordinary course by post. So, as on what date we will consider the letter has been received? Correct, no? When it is delivered that day, where any legislation requires any documents to be served by post, unless a different intention appears, these three things has to be done, correct? And we will assume that that effect of posting will happen whenever it has been delivered from that day. Correct? Receipt of, you can say, letter. So we had seen one case, Jagdish Singh Nattu Supreme Court case. It was held that where a notice is sent to the landlord by registered post and the same is written by tenant with an endorsement of refusal, still it will be deemed that the notice was served. So just because you refuse it doesn't mean that notice was not served. The notice was legally served. Notice or letter basically, service by post. Then a notice when required under statutory rules to be sent by registered post acknowledgement due is instead sent by registered post only. Is it valid? Valid we have discussed. It is not valid, no? Whatever is given in the act, that you have to follow. See over here what you have seen, first one, section 27. So where any legislation or regulation requires any document to be served by post, then unless a different intention appears, that means if there is nothing specific but just post is written, then these things should happen. Registered post should also happen. But if not, and this is given, that registered post acknowledgement due, that should have been done. Registered post acknowledgement due. So the protection is not available. That you have sent by registered post, that should be sufficient, is not available. What is given in the act, first preference will be given to that.